Howdy! Welcome to a lecture on an overview of legal terminology and concepts. I have prepared this lecture before we start discussing our textbook. We've discussed this in another session, the difference between engineering and legal mindsets. Technology is disruptive. Think of it as a jagged sawtooth going up. If I were going to talk to you today about a new streaming technology for music, you would be disappointed if I started talking about how Edison invented the phonograph, and that led to 78 RPM records, and then 33 1/3, and then 45s, and started talking about compact disc and 8 tracks and the iPods, and you'd be wondering, why is she talking about this? We want to learn about the new technology. Well, law is different. Law is based on precedent. That is, what has happened before. I can't just make something up, right? Like you can in technology. It's about problem solving. By precedent, I mean you have to find the law in either a statute, that is something passed by a legislative body, be it Congress for the nation or one of the 50 states, or common law, which means judge-made law. And here's an observation. Some of our most overwhelming changes to American society have been the result of court decisions from the Supreme Court of the United States, and that is basically common law, judge-made law. Give me some examples. Brown v. Board of Education in the early 50s overturned Plessy v. Ferguson. Plessy v. Ferguson said separate but equal for the different races was legal. Brown v. Board of Education said, no, it's not. A wonderful book everyone should read is Gideon's Trumpet about Gideon v. Florida in the mid-60s, and that overturned the long-standing precedent in this country that people facing felonies were entitled to free legal aid. Before that time, free legal aid was only if you were facing the death penalty. Several cases like this that we will talk about throughout our class. So what you want to remember is technology is that jagged edge going up quickly. Law tends to lag. It's linear. I kind of do the do-do-do-do-do-do when we talk about law because we have to trace something back. There's a current Supreme Court case due out soon, and it's about a crime that happened 7 years ago involving technology. Technology since then has moved forward quite a bit. However, we need to separate technology and the law. The law is the process of what society has deemed acceptable behavior. And as a result, law always lags technology. We have problems in cybersecurity. Ransomware comes out of nowhere, it seems like, to law. So the first thing the law does is try to find existing legal and statutory frameworks to bring charges against those perpetrating ransomware, and then they pass legislation. There was a sad case out of Missouri several years ago, and a mother, an adult, created a fake profile on Facebook and harassed a girl who was a former friend of her daughter's until the girl committed suicide. And unfortunately, they could not find a criminal statute to prosecute this adult. So, of course, Missouri passed a law, just like most states have passed laws against cyberbullying. And even in Texas, the law was passed a few years ago, but it was in reaction to a student's suicide where his parents took the initiative to push forward that law. So law always lags technology. We're going to talk about a few concepts. The biggest concept we're going to talk about is jurisdiction. This is the definition. It's the power of a court or locale to regulate persons, objects, or conducts under their law. Okay, what does that mean? Let me go back to the example of my car being stolen. I go out, my classroom, my car's stolen. They catch the thieves. They are prosecuted under Texas law. Why? Because the crime occurred in Texas. Perhaps one of the car thieves says, hey, I'm not from Texas, I'm from Oklahoma. I want to be prosecuted under Oklahoma law. No, jurisdiction is determined by the power of the courts to regulate within their geographic area. Now, here's the problem. The internet doesn't know distances. There is no distance. So we have a lot of jurisdictional issues that come up when we talk about cybersecurity cases. If my identity is stolen and it's stolen by hackers overseas, where's jurisdiction? Is it here in Texas because this is where I was? Is it in New York because that was the headquarters for my bank? Is it in the country where they perpetrated the crime? Typically, in physical objects, jurisdiction is in the area where the crime was perpetrated. But that does not hold true in cybersecurity. Now, especially for those of you who are from outside the United States, it's confusing. We basically operate under 51 laws. We have an overarching federal law, and then each state has its own law. What people do not understand is that even within Texas, we have a discrepancy about how state law is applied because we are in 14 appellate districts. An appellate district means the next level of courts. So your lowest level of courts are your district courts. And then if you appeal or something has to go up for review, it goes to the second level, the appellate courts. And the state of Texas has their courts based on their counties, which is something like 245. But then there's these counties are organized into 14 appellate court districts. And Texas law is sometimes administered in one appellate district based on their common law or court precedent differently than another appellate district. The only time the question gets settled if it goes to the ultimate courts in Texas, and this is where Texas is rather unique, we have an appellate system that handles all civil and criminal cases, but when we get to the Texas Supreme Court, that court only is the Supreme Court for civil cases, non-criminal, and its sister court is the Texas Court of Criminal Appeals, which sounds like an appellate court, but is actually the highest court for criminal. So it's together at the mid-level, separate at the higher level. This is also true in the U.S. We have 11 federal appellate districts. Texas is in the Fifth Circuit. Our appellate courts are in New Orleans. If U.S. law is interpreted and goes to the appellate, it is interpreted by the Fifth Circuit. And the states that are shown here in the Fifth Circuit, Texas, Louisiana, and Mississippi, have to abide by that. It is not uncommon in the United States to have federal laws applied differently. The Ninth District turns to be rather liberal. Its court is in San Francisco, I believe, California. It also has different appellate opinions, very progressive appellate opinions supporting Silicon Valley. The district that has Delaware, which is the third district, which is where a lot of businesses are incorporated, also has its interpretation differently. And the Seventh Court of Appeals out of Chicago also. So we follow we follow all the appellate districts, but those seem to be the dominant ones. Here's the outstanding point for you to take. At the appellate level, the review level that interprets the law can be applied differently within the United States according to these 11 circuits, and as an example, within Texas, according to its 14 appellate courts. The only time in the U.S. we have one law governing everything is if there is a conflict in the circuits or a question gets posed and accepted for certiorari, for review by the United States Supreme Court. And when the Supreme Court of the United States issues opinion, it wipes out anything from the 11 appellate districts. That is our unifying code of law. Now, let's not confuse jurisdiction with venue. Venue is a geographical term. It's a locale where a case can be heard. So, for instance, before coming to Texas A&M, I practiced some limited law. I did a lot of contracts. I always put a term in my contracts that the contract was bound by the laws of the state of Texas, with venue in fill in the county, typically Harris County, which is Houston. So it's a locale where the case can be heard. Now, we've talked about jurisdiction, we've talked about venue, and a very important concept to get is standing. You have a constitutional right to bring a lawsuit. It's under Article 3. But to do that, you must fulfill 3 elements. You must have suffered an injury. That injury must be traceable to whomever you are suing, and it must be redressed if the courts rule for the plaintiff. So let me give you an example. I look out my window and I see somebody run a red light, and it angers me, so I sue him. Do I have standing? No, I didn't suffer an injury. Or I look out my window, I see somebody run a red light and hit a school bus full of children, and I'm angry, so I sue that person. Did I suffer an injury? No, I was not on the school bus. Now, I've suffered an injury, but can I trace it to the defendant's behavior? This becomes hard in some cybersecurity cases. I know my identity was stolen. Someone has been using my financial accounts, but I can't prove that it was because of Party A's data breach. So yes, Party A caused a data breach. Let's say it's my bank or a credit card, and bad things happen, but I can't trace it back to the defendant's behavior. It's causal. I think it's there, but I can't prove it definitively, legally. Furthermore, can my injury be redressed? You'll see in Chapter 1 that a lot of cybersecurity cases are dismissed for lack of standing. And when this happens, a lot of times it's because, hey, yeah, you were a data breach, and yes, you did prove it was traceable to Party A, but they gave you $50 and they took away all the charges, so we're not sure really what you want, right? Let me give you some examples of how standing is used. There is a sad case out of Oregon, and you can Google this and I will find his name, but there was a lawyer in Portland, Oregon, and he was arrested by the FBI several years ago after the Madrid bombing. He was arrested because the government had his fingerprints, because all lawyers are fingerprinted, and he had a partial print match that they found from one of the terrorists that caused the Madrid subway bombing. He proclaimed his innocence and said he had never been to Spain. However, he was arrested under the Patriot Act. He was a lawyer. He lived in Portland, Oregon. He was married to an Egyptian woman, and he had converted to being a Muslim. So it looked bad. It took the government about 2 years to realize he was right. He was not a terrorist. He had never been to Spain, up from the U.S., and he wasn't involved. But it took him about 2 years. And they dropped all charges. He had suffered considerably. He was brought under criminal charges. He sued the United States government to have part of the Patriot Act that he had been arrested under declared unconstitutional. It goes to the Supreme Court. The Supreme Court says, dismissed. We're not even going to look at it. You may legally be correct, but you lack standing because you have no active charges against you and you have not been found guilty. So they denied certiorari. They didn't say whether the law was legal or not. Never got to that point. A second case that I think about was a very sad case. For 8 years of my life, I was a court-appointed special advocate called a CASA for foster children out of Travis County. And a man was arrested for sexual assault of one of his CASA kids' younger sister. And so they arrested him. They believed this little girl that this had happened. They issued a search warrant, which is common. And when they searched this man's home, he was a business owner. He had operations in 3 cities. He had 2 girls in college. He had what looked like a really great life. And when they searched his home, they found the crime was much worse. He had videotapes going back 20 years involving children, neighbors' children, friends' children, date rape, drugs, women who had been sexually assaulted who never realized it. So to his credit, and I only say that because a trial would have been horrible, he agreed to plead guilty and he knew he would go to prison forever. Under Texas law, when you file for divorce, typically you file for divorce and you have to wait 30 days. And this is because there's a cooling down period, or somebody almost always will file for divorce and then regret it. So we got filed and then you wait 30 days. Do you really want to pursue the divorce? No, we were just mad. So his wife immediately filed for divorce. And her lawyer petitioned the judge with a motion to waive the 30-day requirement. The man signed over everything to his wife, realizing he was going to prison forever. And when the divorce was to be heard, which was just within a few days of his arrest, the courtroom was filled with parents of the victims who wanted to stop the divorce and stop the property transfer to his wife so that they could sue him for the damage. The judge dismissed the motion because they lacked standing, meaning this: a divorce can only be brought between married couples, so between one spouse against the other spouse. The victim's parents, although ethically and morally had a case, legally they lacked standing, and the judge granted the divorce. Another important legal concept is case and controversy. And what this means is there has to be something to discuss and to fight about. The Supreme Court does not issue advisory opinions, nor do courts. You don't go to a court and say, hey, just in case this might happen, how would you rule? There's no advisory opinions. Is there a case or controversy? Is there actual conflict? Has the conflict been resolved? If it's been resolved or things have moved on, it's moot. Now, here's something you want to pay attention to. We're going to talk about evidence standards. Civil and criminal. We have 2 aspects of law. Criminal is statutes. You're not going to be tried under common law. You're going to be tried under a statute. You're going to be found, arrested, indicted for a crime, and then you're going to be tried under a criminal statute, right? You don't want a judge to write an opinion creating a crime. Now, courts do write opinions affecting the criminal legal process, but that's different. Civil or non-criminal. Contract disputes, family law, torts, which is, negligence. Somebody runs a stoplight and hits my car. That's a tort. You were negligent. And that's civil. Civil is entity against entity, or person against person, or person against entity, okay? We bring that. Criminal is government against an individual. If I am a victim, I am not the one that brings the criminal charges and prosecutes it. That is the government. Now, sometimes in a crime, you will have a criminal indictment and the victim will bring civil action against the perpetrator. There's a big difference between the evidence standards of the two. Criminal is beyond a reasonable doubt. And I've copied part of the Supreme Court of the United States opinion that defines that. Such doubt as would give rise to a grave uncertainty raised in your mind by reasons of the unsatisfactory character of the evidence or lack thereof. Okay, it's a legal definition, right? Beyond a reasonable doubt. So many times you'll read in the media or people get upset where someone who obviously did the crime is found not guilty, and it's because the government could not prove the case beyond a reasonable doubt. Now, keep in mind that in criminal, you have two results that come out of that, guilty or not guilty. It is not guilty or innocent. It is guilty or not guilty. Did you meet the evidence standards? Yeah, some people have declared not guilty are in fact innocent, but not all. This is a very high bar. We contrast that with civil, which is a preponderance of the evidence. Think of it as 51% to 49%. More likely than not. So for instance, in the O.J. murder case, he was found not guilty criminally, but one of his victims' family sued him and won in civil court because of the difference in the evidence standards. Sometimes in civil proceedings, but not in court cases, you have to use a higher standard called clear and convincing evidence, which is between preponderance of the evidence and beyond a reasonable doubt, which means substantially more likely than not to be true. Somewhere higher than the 51%, but below beyond reasonable doubt. You can see why there's a lot of wiggle room in the legal, even with the court opinions and statutes. So we have civil, we have criminal, and under criminal I've also put a fourth evidence standard called probable cause. And we're going to discuss this in detail later on when we discuss the Fourth Amendment. To get a search warrant, you don't have to prove to the judge that you are beyond a reasonable doubt. What you have to prove to the judge is that there is probable cause. You have reasonable belief and reasonable suspicion, and you are willing to sign an affidavit under threat of perjury that you have reasonable belief and reasonable suspicion based on credible evidence. Probable cause is for search warrants, is for arrest, is for things that lead to a charge which will eventually take an individual to court for a criminal trial. Now, I've talked about judge-made law, and this again is important. A lot of your cybersecurity cases that are not based on criminal will be based on common law. So for instance, a lot of our law about contracts, you don't find the statutes. We do have a business code of law in Texas, as other states do. However, a lot of the issues about contracts have come about from precedent through judge-made law. What constitutes a contract and the like. Now let's think about this. There is a law that says, for instance, if you buy real estate, you have to have a written contract. All right? There is a law that says certain things can be oral contracts, that has to be in written contracts. But your legal precedent of what constitutes contract breach, much of that comes from court opinions. So it's statute about what requires a contract, but then interpretation of the contract is many times based on contract breach. So the first thing I would do if somebody says to my client, you breached the contract, is first of all determine, was it a material breach? Was it a significant breach? And second of all, go search the latest court opinions to prove that argument wrong. There's also a lot of court cases placed on breach of implied warranty. Again, there's something in Texas that talks about your commercial code, buying and selling, this type of code. But a lot of what constitutes a breach of implied warranty, especially applied to cybersecurity, is based on common law, judge-made law. Same's true with negligence. We talk about negligence a lot. Was the bank negligent in not encrypting my data? Okay, was the lawyer negligent in sending my files through an insecure network and allowing my intellectual property to be stolen? There's also an interesting common law called unjust enrichment, and I really kind of love this one. Unjust enrichment works like this. Let's say that I steal money from you under contract. I have $100,000. I steal it. And contract damages are usually put the plaintiff back in the position he or she should have been in. So I steal $100,000. I say, okay, you're right. Court says you're out contract breach, and there's a statutory interest of so much, so you owe $105,000. But in the meantime, I took that $100,000 and I gambled it on Bitcoin, and I have now got $300,000, and I pay you back the $105,000 under contract breach. And guess what? I'm ahead. I have been unjustly enriched. So we have a cause of action by the courts, common law, in Texas for unjust enrichment. And that's one of the best cases I can think about. There are some cases where banks made a mistake and put money in the wrong account in one case, and the guy took the money and he put it in a stockbroker's account and he wouldn't give it back to him, and by the time he gave it back to him, he had made a big profit, and that's kind of unjust enrichment. Fraud can be both civil or criminal, and that's basically where somebody misrepresented. Slander we talk about. You'll see this in cases again. Somebody posted something on the internet. Slander or libel. And the last one, invasion of privacy. All I'm doing right now is introducing these concepts to you and giving you an idea of how each of them works. We will talk about many of them in detail in this course. Now, I need to align this and make sure this is the discussion activity, but I would like to get some discussion with you, and I realize this is online, and because I want you to think about how cyber attacks and pursuing criminals or court cases are complicated because of jurisdiction, standing, or being a moot case. And we'll set this up. We'll have some online discussion. This ends a brief introduction to legal concepts and terminology. Thank you for your time.